Group LLC, the appellant.
Okay, I don't see you on my screen, Mr. Farrar. Is your camera on?
It is now.
There you are. Okay. All right, you're up.
May it please the court, my name is Michael Farrar and I represent the appellant East Winds Consulting LLC. I'm requesting 4 minutes for rebuttal. This is a surplus case. It's an association foreclosure case. There are no subordinate lien holders in the foreclosure. After final judgment and sale of the property, appellee Amerifund Enterprise Group appeared in the county court and claimed to represent one and only one heir of the owner of record. The owner of record's name is Zelphia Lyles. Amerifund obtained all of the available surplus, which was approximately $71,000. East Winds appeared shortly after that order of disbursement and objected to the disbursement and moved for rehearing under the claim that it represented 3 heirs of the estate.
Can I stop you right there for a minute? We had some concerns about the standing of your client to appear in front of the court since the disbursement had already been made, the judgment had been entered, and along comes East Winds and files for rehearing, not a notice of appearance, not a intervener, but a rehearing. It's sort of hard to even follow why East Winds has any interest in this matter at all. So you might want to address the standing issue before we go into any more detail.
Yes, Your Honor. As far as standing goes, the appellant filed a response to the show cause order. The response was filed on November 28th that provides some detail and context to the show cause order, which requests how can.
And we did receive that, and I looked at that. I just wanted to kind of hear you walk us through it, and I'm interested to hear what opposing counsel has to say, because I don't think we got a reply, at least not yet. Go ahead.
Yes, Your Honor. The Portofino case, which was towards the end of that response, identifies a party as a person who is actively involved in litigation. And it was our contention with the way that we behaved, filing documents, performing the probate, filing the petition for summary administration before the record closed, and then arguing in front of Judge Karasis that we behaved in all the ways that a party who was adequately protecting its interests and the interests of its assignors would behave. Now, more to that point, also under 49021, which is the portion of the Florida statutes that allows classes of defendants to be impleaded, East Winds as an assignee of 3 of the heirs of the estate of Zelphia Lyle also falls within the category of being an heir and therefore a party to the proceeding, as it's stated in the caption of the amended complaint, the heirs of Zelphia Lyles. Those are the 2 major bases under which I argued to this court in the response to the show cause order that East Winds Consulting is in fact a party, statutorily under 49021, and then also de facto, also McGregor versus the McGregor case from Florida Supreme Court 1934 also describes parties as people who act in the case, but the Portofino case in particular tracked very closely with what occurred in this case.
Okay.
Thank you, Your Honor.
We'll have to wrestle with all that.
Understood, Your Honor. East Winds objected to the order of disbursement to a person who merely claimed to be an heir and filed a petition for summary administration before the record closed, which Judge Karasis did not state, as you can see from the transcript, said that he couldn't see that petition for summary administration. Of course, eventually an order of summary administration was obtained, but that was after the record closed. I would like to tackle the 2 principal statutory objections that East Wind has to the disbursement order that's under appeal. And the first is that Chapter 45 provides an explicit presumption that the owner of record, as of the date of the filing of the lis pendens, is the person who has a right to surplus after payment of subordinate lien holders. And as I mentioned, there are no subordinate lien holders in this case. That presumption of entitlement to the owner of record must be overcome before a proper order of disbursement can issue. The ability to overcome that, or the presumption of entitlement to the owner of record under 45033 2B is that it can be rebutted only by a voluntary or an involuntary transfer. And in this case, we're going to concentrate on involuntary transfer. An involuntary transfer assignment may be as a result of an inheritance or as a result of the appointment of a guardian. The only authorized methods for proving inheritance rights under Florida law are either an estate administration under the Florida Probate Code, specifically 733-105 sub 1, or a separate civil action in the circuit court to determine beneficiary rights under 733-105 sub 3. Both of those would take place in the circuit court, not in the county court. AEG presented insufficient evidence of entitlement to its client, Curtis Selden. A mere motion to intervene for surplus without more is not sufficient evidence of entitlement because it is at its essence merely attorney argument. Therefore, the motion itself was insufficient in order to obtain an order of disbursement, irrespective of the inheritance issue. Also, AEG, Amerifund Equity Group, as an assignee or contractee of the purported heir, was required under 45032 3B to have an evidentiary hearing demonstrating its right to be the assignee and to claim the surplus. That also didn't occur. As a matter of fact, I'm jumping forward a little bit, but no notice of AEG's motion was ever published, and no hearing was ever held on AEG's motion. The judge simply issued the order. I don't know how. But in order to be in conformity with the statute, specifically 45032 3B, the evidentiary hearing was required to take place, and without that hearing taking place, procedural due process was violated. And I cited one of one of my favorite cases that comes from this court, Schlissy the Best versus City Financial Equity. So in terms of providing evidence of entitlement, AEG provided nothing that would overcome the presumption that is baked into the cake in statute, specifically 45033 sub 1, regarding the presumption being that the former owner of record is the person entitled to the surplus. Now, the second statutory basis that demonstrates that the order of disbursement was improper is that this case arises from the county court. Judge Karasis is the county court judge. Under 26021-2B, only circuit courts have a right to be able to determine beneficiaries or other matters relating to probates. When Judge Karasis ordered the disbursement entirely to AEG, it was affirming Curtis Selden's status as heir of Zelphia Lyles. Judge Karasis did not have the statutory or the Florida constitutional authority to do so. So that would be the second statutory basis under which the order of disbursement was improperly entered. Finally, I would like to circle back a little bit to the lack of due process. The order of disbursement was issued without notice or hearing. It's a clear violation of due process. That also would be another basis for overturning the order of disbursement. Opposing counsel stated that this matter was brought up for the first time in the appeal. That's not technically correct, but because a violation of due process is a fundamental error, it could be brought up for the first time in appeal. And if the panel does not have any additional or any questions, then I yield back the balance of my time for rebuttal.
Okay, thank you, Mr. Farrar. Mr. Loftus.
May it please the court. My name is Kevin Loftus. I represent Amerifund Equity Group as the appointee of Curtis Selden. Very quickly regarding the issue of standing, it's AmeriFund's position that they have no standing. They're not a party to the case and should not be allowed to file motions, be heard, or to pursue an appeal. There's a mechanism for intervening in a case, to file a motion for intervention. The arguments that Mr. Farrar makes in support of his being allowed to intervene should have been made. And if he had been granted leave to intervene, then he could be heard further. But all the reasons for entering the case or being granted leave to intervene are moot because the surplus has already been dispersed to AmeriFund and then on to Mr. Selden and the heirs. There's no surplus for the trial court to disperse any further. This case is not the forum for East Wind's issues. It would appear that they have what they would claim to be a breach of contract claim against the heirs that they had signed. They have appointment agreements with 3 of them, I believe, to go ahead and have East Winds pursue the surplus that AmeriFund has already claimed and provided to them. So I don't know how successful that claim would be, but this isn't the mechanism to pursue it.
I have in my notes that the AEG's motion for surplus distribution was October the 12th, 2021. The order dispersing was November 2, 2021. And the first time East Winds appears is November 12, 2021. And they appear by means of a motion for rehearing. That's their attempted entree into the case. Is that the way you have it?
That's correct. And while we're on that aspect of it, regarding the notice requirement, I don't know how AmeriFund was supposed to notice East Winds Consulting about the order and all that or anything if they weren't a party or had filed anything to let us know before we had already resolved the case. Regarding the due process to the heirs, as was represented to Judge Karasis at the motion for rehearing, it's in the transcript. Curtis Selden had an agreement with the rest of the heirs to represent their interests, to seek the surplus and then distribute it equally to the remaining heirs. And Judge Karasis accepted that representation and is what ultimately happened. There's no due process. I mean, East Winds Consulting wasn't entitled to any due process because, again, they're not a party and we weren't aware of them and had no reason to suspect or to ask to be, or I don't know who else we were supposed to notice, frankly, since the case had already been resolved to the satisfaction of everybody who's involved. And as you can see from the record, no one else is complaining about this. Not the judge, not AmeriFund, not Mr. Selden, not any of the heirs, just East Winds Consulting. And I believe it's apparent from reading the transcript from the hearing in March that the trial court was aware of what's happening, that AmeriFund signed the heirs, they received the surplus, they got paid, the case is over. And now East Winds Consulting is coming in after the fact, after it's done, trying to enforce 3 contracts that never should have been signed to get surplus that's already gone with the argument that, hey, we've put all this work into it now and now we need to get paid. They did an unnecessary probate when all the heirs were in agreement as to how everything should be distributed. The summary administration order is incorrect. At the hearing in March, Mr. Farrar himself asked Mr. Selden whether or not his mother was still alive, and he said that she was dead. But then somehow he got an order out of the probate court saying that Barbara Selden is alive and entitled to some of the distribution. And then in his briefs to you says that Curtis Selden is not recognized as an heir based on the order that he got out of the probate court. Let's see. The
probate proceedings weren't begun until March of 2022. Is that right?
Yeah, I believe he filed it on March the 1st. The hearing on the rehearing was March the 2nd. So the information that he received from Mr. Selden about the death of his mother and from me about the existence of AmeriFund, because he argued that AmeriFund doesn't even exist, So he was fully aware of that information when he went to the probate court and got the order that he got issued. Regarding the issue about probate being required, it's not required by the statute. There's nothing in it that suggests that. There's no case law that suggests that. The trial courts, both county and circuit, are determining who has entitlement, and a probate order is evidence of that. But as also a will is evidence of that. A testimony from heirs is evidence of that. And once the court is satisfied that the correct people are getting the correct distribution, they rule on these things fairly regularly. Now, regarding the hearing, the statute does say that a hearing, evidentiary hearing, is required, but that is not the standard practice. Generally, when all the parties, and in this case, all the parties are in agreement on how the disbursement should be made, that order is presented to the courts and they routinely sign them. Sometimes the courts require a hearing, but it's not an evidentiary hearing, just a motion calendar where everyone comes in and he can see us and give the thumbs up, and then the order will sign, the judge will sign the order. So the fact that no hearing was made in this case, I don't think is relevant, because again, all of the parties and all the affected people were already in agreement as to the result. The only people complaining are East Winds, who are not a party and have no claim because the heirs already had the disbursements made and the heirs already have the money. I guess last is my liability personally for the money that was dispersed from the registry. The case law that's cited there is correct, that the attorney should be held liable when it's taken without notice to parties. But that is not the case here, as again, East Winds is not a party. Everyone who's involved is aware of what happened. The money was dispersed appropriately and the heirs are in possession of the money. I think that covers everything. I would just reiterate that the judge ruled the first time based on my representation, my motion, and the judge ruled the second time based on my representation, my motion, and the representations of Curtis Selden. And I believe he ruled appropriately both times. And now they're seeking to do it again so that East Winds can get paid for something that AEG has already done. And I have nothing further for you guys.
Thank you, Mr. Loftus. Okay, Mr. Farrar to rebut.
Thank you, Your Honor. A personal representative has a right to control estate assets. There is no personal representative. There never was a personal representative. And Curtis Selden never made an attempt to make himself a personal representative in order to take all of the surplus from the estate of Zelphia Lyles. So the claim that he was designated is not in the record. The claim by opposing counsel that, quote, all the heirs are in agreement is also not in the record. It happens to be false. The claim by opposing counsel that is not in the record, the heirs already have the money, is also false. What we have here is somebody claiming to be an heir without any probate court order, going in represented by a fund recovery company, receiving all the money and taking it. It's really not more complicated than that. There are additional post-record, in other words, let's say from March of this year to the present, events that have occurred, including entry of the order of summary administration, which does not show AEG's client Curtis Selden to be an heir, and which Attorney Loftus was completely notified on from the inception of the probate and posted no objection to the order. But bottom line is, we have a county court judge making a probate determination, giving all the money to somebody claiming to be an heir with absolutely no probate information provided. I would like to note under 45033 sub 2, there are two classifications of the involuntary transfer. One is, quote, as a result of an inheritance. The other is appointment of a guardian. I think that this court would be very skeptical of any judge that authorized disbursement to somebody who simply came in and without an evidentiary hearing or any other argument claimed to be appointed as a guardian. The same should also be true of anybody who comes in and claims to be an heir. As the supplemental filing demonstrates, Curtis Selden is not an heir of the estate, or at least not a direct heir of the estate. He may be a nephew, but that's a separate matter.
What about counsel's remark that this is the sort of thing that could be brought in terms of a breach of contract or a fraud or motion to set aside or some vehicle other than the fact that this disbursement has already taken place and the cases and the appearance came after the fact by East Winds?
Well, this court has overturned disbursement orders in which the surplus has been dispersed. And as a matter of fact, in the Reveri case that I cite, the Third District Court of Appeals case, the money was gone and the appellate court ordered it paid back, and the attorney jointly and severally liable for its return if it were not paid back. So the fact that the money has been dispersed shouldn't really impact whether a county court judge had subject matter jurisdiction to issue the order, or whether notice and a right to be heard were violated, or whether evidence sufficient to overcome the presumption of entitlement to the owner of record have been presented.
Okay.
Okay, anything else?
No, Your Honor.
Okay. Thank you both very
Thank
much.
you.
Thank you.
In order to leave our virtual courtroom.